All right, welcome back to Gear, getting excited about research. We're getting you all geared up for your literature reviews. I'm Dr. Robert Shug. We have today our special guest, Dr. Christine Scott Hayward.
Hi.
And Dr. Scott Hayward is going to be talking about some research she's done titled, Does Privacy Require Secrecy? Societal Expectations of Privacy in the Digital Age. Yes. So welcome, Dr. Scott
Thank
Hayward.
you very much. It's happy to be here.
You're happy to be here.
I'm happy to be here. It's happy. The research is happy to be here.
The research is happy to be here, of course. Okay, so you've given this talk in several venues.
Yes.
Tell us a little bit about that.
Yeah, I've given it to academic audiences. I gave it at the annual meetings of the Law and Society Association, which is mostly lawyers, law professors. I gave it at the American Society of Criminology annual meeting. Traditional criminal justice venue. And then just this week, as part of Law Day celebrations, I gave it to two groups of high school students at a local high school here in Long Beach.
Okay, and how has it been going over? How has it been received?
People are interested in it. Most recently at this at the high school, I think the engineering students were quite interested in it because of the technological implications and how our legal system doesn't necessarily always really understand how changes in technology impact the law.
Right, and actually I was very excited for you to give this talk today or to tell us about it because of the way that in setting it up and telling the story you've woven in case law. Mm-hmm. And since this is a course on criminology, criminal justice, it's very appropriate to be using case law and other sort of legal areas to set up the stage for our research questions. So I was really excited that you did that in this talk.
Yeah, I mean that's my research tends to look at the practical implications of our criminal justice system, particularly our criminal justice legal system. I'm a law and society scholar. And so I sort of bridge the two disciplines, and I rely on both social science research as well as legal research and obviously case law.
Great. Okay, so set this up for us. What's the backstory?
So the backstory to this project is the Fourth Amendment. So as you probably all know, the Fourth Amendment protects a lot of things, including your privacy rights. And in the past, the Fourth Amendment has generally not done a great job of handling changes in technology. And so we have a few doctrines that exist in Fourth Amendment law, including the Katz reasonable expectation of privacy test, which sounds a little complicated, but basically just means that if you have an expectation of privacy in certain of your information, and society accepts that expectation as reasonable, then the government needs a warrant to access the information. Right. If you don't have privacy expectations, then no warrant. The government can just come in and take your information when you want. Okay. So that's sort of the framework. And then there's also this doctrine called the third party doctrine, which says that once you give up some of your information to a private company, so if I give my banking information to a bank, right? I give information about how much money I have to the bank. I no longer have any privacy expectations in that information. So police don't need a warrant. They can just subpoena the bank and get the information from them.
And this affects all of us as U.S. citizens.
Affects all of us as U.S. citizens, right? And so it used to be, okay, well, that's fair enough. You don't give up, if you give information to a private company, that's a conscious decision. But over the last few years, it's become increasingly apparent, and Justice Sotomayor on the Supreme Court has made numerous allusions to this in cases, that you can't really live a life today in the digital age where so much of our information is online without giving up some of that information. Yeah. So the question is, have we said, okay, well, we want to live an online life and therefore we're going to give up some of our privacy rights? Or have we said, well, we want to live an online life, but we also want to retain our privacy rights? And so the purpose of this research was sort of to say, okay, well, what do people actually think about this?
Right. Okay. Great. And then so then what was the next step then?
So we conducted a survey.
Okay.
So there had been a little bit of research before in this area where people had asked the population about how much they agree or disagree with certain decisions of the US Supreme Court. We wanted to take it back a little bit further and sort of just ask individuals, when should the government have access to certain parts of your information? Under what circumstances? Anytime, if a police officer has a gut instinct that you might have done something wrong, all the way to probable cause. So there's a fair probability that you have committed a crime or that you have information about a crime, to never. So we asked our survey respondents those questions about a whole variety of information, everything. Sorry, go ahead.
No, I was going to say, is the previous research in this area generally survey-based?
It is survey-based. Yeah, there aren't really any other. Well, so there aren't any other ways to do this really empirically.
Yeah.
The Supreme Court decides when you have an expectation of privacy based on a whole range of tests that it uses, but most of them don't rely on actual empirical information.
Okay. And then did you have these specific research questions going in?
Yes.
Okay.
Yeah.
What were those?
So we were interested in finding out, sort of, one of the questions was about whether people were in favor of the third-party doctrine. So did they think that the third-party doctrine should still then apply in the digital age, or is it now outdated? Okay. Do individuals' actual expectations of privacy match what the Supreme Court has said their expectations of privacy actually are? Mm-hmm. And then we had a more subtle question specifically about GPS tracking, which is drawn from the US v. Jones case, which set out a new standard for thinking about approaching to GPS tracking. So that was sort of a smaller question.
Okay. And then what sort of questions were you asking these folks?
So we asked people those questions about a whole series of aspects of information, and you can see those on slide 12. Facebook posts, cloud-based files, things that you post on Dropbox, the email addresses that you receive emails from and send emails to, online search engine history, what you've watched on Netflix, what you've bought on Amazon, when you download an app onto your phone, the kind of information that you give to the app company, text messages, voicemail. So all of these sort of areas that most of us, I think, today are participating in. At least to some extent.
And this was done in person, or how did you administer
This
them?
was done online. We conducted the research in, I believe, the summer of 2014. We had 3 different groups. We surveyed respondents on Facebook. We just used a snowball sample through the 2 principal investigators' Facebook accounts. We surveyed students here at Cal State Long Beach, undergraduate and graduate. And then our largest portion came from a tool called Mechanical Turk, which is run through Amazon, and it's a way to to do surveys or have people online do tasks for you in a very inexpensive way.
It's really becoming more and more popular, actually.
It's becoming more and more popular, and actually, as an aside, we're also working on a methods piece. We compare all of these 3 different samples. We haven't completed that yet, but we're comparing those 3 samples to see how reliable is this new source of information. Because you can do a public opinion poll, but it costs an awful lot of money. And if you can get as good or almost as good information from MTurk for a lot less money, then especially for student researchers, it's a really good way to think about gathering data.
Right. Great. Okay. So what'd you find?
Well, we found that with the exception of public Facebook posts, not surprisingly, given that information is out there already, the vast majority of individuals think that the police should have access to a warrant or should never have access to the digital information. And so, high proportions of people for everything from private Facebook posts to documents stored on the cloud, to cell site location tracking. So I don't know how many people know about how your cell phone is tracked, but we now have GPS tracking in most of our phones, but even if you turn that off, your location can still be tracked by the cell phone company. How they do that is they triangulate your location based on the pings that your cell phone sends to the towers when you make a call.
Even when it's off?
It depends. Generally, when it's off, you're okay. But as soon as you turn it on, even if you're not making a call, then your location can be tracked. And the charts, you can see looking at the slides, they all look the same, right? The pattern is the same. So very small proportions of people think, the police should always have sort of access to this information. Maybe if they require that, they be based on their experience. But the vast majority of individuals for all of these different areas of your digital life want the police to have to get a warrant.
So it looks like the way you grouped these graphs is sort of the darker colors or more liberal sort of limitations for the police, like they should have them anytime, whereas the green or lighter becomes it's more restrictive.
Exactly,
right?
because in this area, everything that we're talking about here and throughout criminal procedure and Fourth Amendment law in particular, you're constantly balancing the need for law enforcement to have the ability to conduct investigations, solve crimes, prevent crimes, et cetera, with individual privacy rights. And so you're balancing that all the time. And the warrant requirement is sort of the epitome of that balancing act, where you require that the police have some knowledge or information in order to start, digging deeper.
Right.
And that's a historical thing. It gets back to, in the United Kingdom before we revolted, there was what was called a general warrants clause, and I could just have a grudge against Dr. Shug and decide that I just want to go into his house and see if he has anything and just go on a fishing expedition.
Yeah.
And so we were very specific as a country when we added the Fourth Amendment in the Bill of Rights to make sure that there had to be probable cause before accessing a warrant.
And it looks like by and large, folks are sort of demanding probable cause, or that's like the
Exactly.
most popular response.
Yeah, exactly. And if you look at, we did this summary on page 22 where we sort of ranked the variables and we combined then those last two categories, the probable cause or never. And that's interesting, like the numbers of never, where even with a warrant, some people think that the police should not be able to access information, which is, not going to happen. But
I wonder about those people.
Yeah.
What are they hiding?
But there's also that small group of people who think that the public Facebook posts should never be allowed to be viewed by the police, and that's just out there. But you can see that people had sort of the highest, if you want to frame it that way, the highest expectations of privacy in voicemails and text messages, and then sort of going down a little bit further. And if with all of the variables, it's not shown on the chart, we just listed the top 10, but with the exception of public Facebook posts, a minimum of 74% of respondents expected a warrant or higher for all of those areas of data.
And differences among the demographics?
Some differences, but not huge. So we found that men on most of the variables had a slightly higher expectation of privacy than women. Independents had higher expectations of privacy for the cell site and GPS location traffic information. But otherwise, not too many distinctions among the groups. It was a fairly consistent. And we were surprised by the magnitude of the results. And we have, we've talked to some other scholars. There's another group of scholars who actually had the resources and did a public opinion poll, and they found results similar to ours. They used MTurk as their pilot, and what they found was that the MTurk results were slightly higher than, like, they sort of had sort of more expectations of privacy in areas than the public opinion group, but not by much. And so even if you say, well, maybe this population might be a little bit different from the regular population, even if you drop those numbers down a little bit, you still have a really clear pattern.
Were you surprised with how the research questions got answered through this study?
I wasn't. So I got interested in this back when I clerked for a magistrate judge in the federal system, and one of the things that magistrates do is they will get requests for warrants, but also for orders under the Stored Communications Act, which regulates the cell site location tracking. We had all these conversations. He felt that it was sort of disingenuous to say that people didn't have expectations of privacy in this information. He said people wouldn't, he thought that people wouldn't read the user agreements, that they didn't really know how much information they were giving up when they agreed to just use a cell phone. And so sort of he was questioning, he's like, we don't actually know, what's going on here. But I think anecdotally, I wasn't surprised. I was surprised by the magnitude, just how many people. I thought it would be a little bit more nuanced, particularly in the middle.
Okay, and what's it mean for the Fourth Amendment? What's it mean for law and policy?
Well, I think, as I said earlier, the Supreme Court has, and federal courts generally have, a few different ways that they think about when an individual should have, when an individual's personal expectation of privacy should be recognized as being objectively reasonable. And none of the ways that they do it right now actually involve looking at what society thinks. And I think that there are certain areas where this information could be helpful. So we're not suggesting that, okay, well, take this Supreme Court and now, make your decisions based on this research, but use this research and use other research, other public opinion, poll-based research that gives a good sense of what society thinks, and consider that when you're determining, what the meaning of some of these categories are.
Gotcha. It's a fascinating study. Let me sort of switch gears for a second, if you will. In terms of, as a professional writer, weaving in case law, tell us a little bit about when you think that's appropriate. When is it a good idea? How does it help contribute to the literature review?
Yeah, I mean, it depends what your question is. I think if you're looking at a legal question, you're generally always going to have some case law in there, even if it's just background. If you're doing studies on sort of police brutality, for example, that there's some key Supreme Court cases that sort of set the frame for how questions need to be examined.
Right.
And if you're doing research and you want that research to be useful to practitioners and policymakers, which is my goal in conducting research. You want to frame it in a way that makes it useful to them. And so if you just go out and do a study that has no relationship to the existing legal framework, which is the backdrop to the area, then it doesn't, nobody's ever going to read what you...
Kind of tying it into the real world, I guess.
Yeah, exactly, exactly, yeah.
Okay.
Yeah.
So what do you do when you get stuck writing?
Just leave. No, I mean, I think seriously, taking a break, right? So I always try and have a couple of different things going on at the same time. And so if I'm bogged down on one area, leave it, go away, work on something else, go for a run, take a break. You can't force it to come. If you're stuck on something, sitting there and staring at your computer is not going to help.
Almost makes it worse, right?
It makes it worse, yeah, because then you start feeling down, you feel like you're wasting time. So, I have I do to-do lists all by hand. I write a lot by hand. So I'll also, if I'm stuck on something, I'll print it out. And I'll edit it by hand, and that's how I roll, because you can't see things. And I tell my students to do that too. Sometimes I'll even say start reading it, reading it out loud, and that way
it's a different process, a different dynamic when you're doing interacting with the screen versus with a pen and paper.
Yeah. So at the early stages of my research, I'm often using a pen and paper, and I'm sort of just jotting down ideas and sort of drawing little diagrams and sort of figuring things out. And then as soon as I start writing, I'm obviously on the computer. But then I go back to the paper and the pen, and then
You're sort of like a Leonardo da Vinci of research writing, actually.
That's exactly what I am.
I want to thank you so much for joining us today, Dr.
No
Scott
problem.
Hayward.
Thank you very much. I hope it was helpful.
It certainly was, and we'll see you next time on Gear.